All right, good afternoon, everybody. It is time for our weekly work comp today, where each month David and I and one of our fellow practitioners get together and we talk work comp stuff. We talk about employers, employees, and independent contractors, and really anything that impacts employment settings, particularly when people get hurt or the pandemic, and I got to pick on them as we do every month, Amazon. So welcome to the monthly YouTube show. We've got our friend, longtime friend, colleague who we rely on and have a great friendship with, Lindsey Simmons out of King Simmons with multiple offices, but she's down in the Fairhope. Lindsey, thank you for joining us.
Hi, thanks for having me.
Oh, it is absolutely our pleasure. Dave, you can speak anytime where there's a break, so go for it.
Hey, welcome. Glad you joined us, Lindsey. Appreciate it.
Thanks for having me.
We are very, very pleased that Lindsey's with us, and we're going to do our usual format. We've got 5 articles from different parts of the country. We've also got some Alabama law to talk about. But before we get into that, Lindsey, here's your time to kind of promote your practice a little bit. Tell us, David and I know about King Simmons, but we want the world to know about it. So share a little bit about
it. Oh, my. I am a partner in King Simmons. We are, we do the same thing basically as the Nombergs, but have a great working relationship with them. So we do have offices in Birmingham, now in South Alabama. So I moved down here about 2 years ago and opened our office up down here. So I basically handle everything south of Montgomery, and then my partner Larry and the folks up there handle north. So, but yeah, we do obviously a ton of work comp, personal injury. I also do a lot of, we also do a lot of employment law. So a lot of retaliatory discharge, those types of things. So yeah, we have a fun practice.
It is. And you have, I think you made out best, moving down to the beach and the Gulf, and we're stuck up in North Alabama. So whatever prompted that move, April.
Right. I know. It really took a good twist of my arm to, move down here. It's really just a horrible place to be.
Lindsey, is there a big difference in practicing law in Birmingham than now where you are in Fairhope?
Yeah, I would say so. I've been here 2 years. So I'm from the Birmingham area, the great city of Hueytown. And so, when I was practicing up there, I was very familiar with, the surrounding areas of Birmingham and then, just other towns around. And so coming down here, obviously I'd been to the beach through the years, but I've had to learn a lot about, the Mobile area and the Baldwin County area. And, there is a different, there's different types of industries down here. So to me, it's there's a lot of construction and there's a lot of, those types of cases. So I think there's probably more of those down here. So it's a little bit just of a different, type of practice.
Well, there's so many similarities, but there are a lot of differences. You're right, the types of cases and so forth. And let me just get one thing set up. I think we're good now, guys. All right, let's jump into these articles that we have on board. And we've got a series of articles. We try to keep them as timely as we can. Unfortunately, a lot of them have had the pandemic theme woven through there. There's been a lot of articles this past year about medical marijuana use, about telecommuting, and we still have a lot of that going on, but we're also seeing some new things that are starting to pop up as hot topics. This first article actually is based out of Australia, and the title is Employees Can Choose Where They Want to Be. Now, Lindsey, David and I have handled some telecommuting cases where you work, working remotely. I'm sure you guys have looked at them or handled them as well. But this seems not just in the States, of course, but really around the world, there has been a real trend to working away from the office. And I think it's a great thing. And what do you get out of this that practitioners may want to focus on?
Well, I mean, and I think y'all probably seen this too, is we've had calls from time to time of folks who are now working from home and they have an injury. And the question is, well, is it work comp? If I'm working out of my home office and I, go to the kitchen to have my lunch or whatever it may be, or I'm, and I trip over my dog, am I going to get work comp because I'm on the job, I'm working? But so, I think that it's going to open a lot of interpretation up to, well, is that something? If you have some type of injury on the job, but you're working out of your home office, is that going to trigger work comp benefits? And so, I've looked at a few, and I think those could be really, really tough. I don't know about y'all. I don't know if y'all seen any that, were kind of clear cut, but.
I don't think any of it's clear cut, but Dave, from your research, what are you looking for in these kind of cases to show maybe it would be a case that could be compensable?
Yeah. So Lindsey, we put together a list, Bernard and I did, of all reported telecommuting cases from the United States over the last 20 years, because we did a presentation on that topic, a seminar, and it was really interesting because you hit on a few things, Lindsey. It was the family pet, ice, and stairs were three of the major components where people were injured, in the bulk of those cases involved slipping in ice, tripping over an animal, or stairs. Mm-hmm. And so some were found to be compensable, meaning they were covered by the employer's work comp, and some were not considered, were not fall under work comp. But it was interesting, and some of the keys for both the injured worker or for the employee and the employer is to have designated workspace for the injured, for the I keep saying injured, for the employee, and have designated work hours as well, so that at 3 a.m. If something happens, that's probably outside the normal work time. Mm-hmm. But it was interesting to do that research, and about the article, while it does talk about work life in Australia, I mean, this article could apply to the U.S. as well. And while so many of our clients work at warehouses or hospitals or factories, and working from home is not going to be applicable to them because they work on a line or they're at a place where they have to take care of something or take care of people. I think we are going to see more and more people working from home because we've seen how easy it is, and it can save employers money. And that's going to be the big thing right there is it going to save employers money to have people working from home? Meaning, do they need less square footage?
Yeah, and I was going to say that my brother works for Protective Life up there in Birmingham. Mm-hmm. Y'all know how large, that facility is and how many employees they have. And so, during COVID, I mean, they sent almost everybody home. And so it was interesting just talking to him throughout this past year of, they're trying to transition back into bringing people back in. And there are some people that are saying, hey, we really like this. We want to stay home. And so I think that employers are going, we may not need to pay this much for this much real estate. And that, like you said, it can't work in every circumstance. But yeah, I mean, I think that, there's going to be a lot of employers that realize, hey, this could really be a big deal for us. So, and their Protective Life, I think they're transitioning back in. They've got, I can't remember the last, maybe half of their staff, physically back, but I don't, who knows if they'll bring everybody back. So I think that we're probably going to see a whole lot more of that, of the work comp questions, because I think more and more people are going to be working remotely.
It is. And it's also creating new job titles. Did you catch this? The company that was featured in this created a position called the head of remote, which has been tasked with building an online culture for the company through virtual clubs, social events, and online education. I don't think either of our firms are big enough for something like that, but that's a pretty cool job title.
I'd like that job. Can I build an online club?
That's right.
Is that?
Well, we got one going right here.
We do. So, yeah, we have our own culture.
All right, let's put a pause on that one, and let's move on to our next one out of California. A new law in California aims to protect workers at retail warehouses. Imagine this, like Amazon. Amazon's easy to pick on because it's, one of the largest retailers in the country. They really, while they get most of the publicity, which is a lot of times bad, they also have a lot of influence. They have a lot of pull in the various states, governments, because they're such a big, they bring so much to the economy for each state and around the country. And California, once again, that usually these articles, Lindsey, that we find, because California usually leads the way, and they're like the ones ripping the Band-Aids off for everybody else to feel the pain, so to speak. But Governor Newsom was at it again. It's supposed to take place this year. California is supposed to be the first state to implement a law that addresses working conditions for warehouse workers. And Dave, what do you take from here? And what do you think Alabama's response might be to something like this?
I mean, this is great for California employees because this law addresses the impact of quotas on worker injury and health. In other words, certain warehouse workers have to meet a quota during their work shift. And this says this legislation protects those workers if they states they can't be fired or retaliated against for failing to meet an unsafe quota. And again, this law is in California. It is not in Alabama and likely will never be in Alabama.
Lindsey, I know that you're only going to echo, but do you have anything else that really caught your attention? Not from a standpoint, well, gosh, I wish Alabama would do this, but from a practitioner standpoint, is there anything that we can use to guide our clients in state about something like this?
Well, there were a couple of things that came to mind. So one was, other than Amazon, because obviously we do have some Amazon facilities that we've got, a new one being built here in Baldwin County. But, and I know you guys see it too. So we've got a lot of the automotive manufacturing plants, the chicken factory, the chicken plants, where you get clients that call you and it is one of those quota type jobs. And so 9 times out of 10, it's going to be like a repetitive use type injury. So carpal tunnel, and so the sad thing is about that is that they are pressured to work so fast. And at the end of the day, when you have one of those claims and you're trying to help that person, and when you tell them what benefits are available for a carpal tunnel type injury, it is ridiculous. Because a lot of times that's the type of jobs that they have their experience in. And so if they have carpal tunnel and they're not able to go back and do those types of jobs again, that puts them, out of the running for a lot of different positions. And so, I noticed that. One other thing that I noticed was there was a mention it's on page 2 of my printed article, but it talks about the Labor Commission was given the authority to issue citations for violations of that quota, or I guess the unsafe quotas. And what came to mind to me there was the impact on firings. So you guys have probably seen this too, where high rates of injury. If you have somebody that's injured in that type of quota position or whatever, a lot of time, at times they will be fired in a retaliatory manner because they have an injury. And so these companies, are worried about their mod rates or their experience ratings under the work comp, which, what those are is basically how many claims do they have. So, it was kind of interesting to me to see that, if they're fining them for having the unsafe quotas, is that going to have an impact on that? So kind of in that same manner of the mod rates or, where they have these really, just crazy quotas on how much they can do. And if they're fined, I'm curious about how that would kind of play into that. And I have no idea if California has like a retaliatory discharge type statute or anything like that, but that came to mind when I was thinking through this.
Why don't you talk about retaliatory discharge, since you've mentioned it, explain what that means in Alabama and what,
Right.
Just talk about that.
So in Alabama, as part of the work comp statute, there is a provision that states that your employer cannot fire you solely for making a work comp claim. So the key is solely. And so it prevents employers from retaliating against individuals who are injured on the job, report that injury, seek treatment, or seek, whether it's treatment or benefits or however you want to look at it. And you have to be able to prove that your employer, that was the one sole reason for your termination. So as y'all can imagine, most employers are not dumb enough to walk up to somebody and say, you're being fired because you made a work comp claim. Mm-hmm. I've had that happen one time, but one time only. So a lot of times they're going to have a reason, whether it's, they're just padding the file, and after you get injured, they're writing you up and they're, making up reasons or whatever it may be. They're generally going to come up with some reason to get rid of you. So at the end of the day, those cases usually are based on or proven through circumstantial evidence. And so there's just kind of a whole wide range of factors that go into that, that we look at. But, it happens a lot. It's just that the employers know, or they think that they can be shielded by the at-will employment rule in Alabama, which is generally your employer can fire you for any reason, bad, good, no reason at all. But if we can kind of pierce that and, show that they really did, they just wanted to get rid of you because you made the work comp claim. That's what we look at. So.
And it's such a tough set of laws with being at-will employment in Alabama, but those mm-hmm. cases do exist, and they're certainly worth pursuing. And I know that you guys at King Simmons do such a great job pursuing those types of cases. And for those of you just joining us or maybe catching us on replay, wanted to welcome you. This is our monthly YouTube live show. It's Work Comp Today, or as Dave calls it, Work Comp for Nerds. But we would be the three nerds today. We've got Lindsey Simmons, our buddy and colleague down in Fairhope, joining us. And we're talking about topics of the month, articles of interest that deal with employers, employees, and independent contractors, and really anything that impacts the employment setting, adversely or otherwise. This is the kind of work that we do, and we're just trying to educate folks a little bit and talk about what the current trends are. Now, one thing that has been in the news for a number of years, but another article came back up and it really caught my attention, and it is injured workers returning home from Afghanistan, may be entitled to compensation. Now, this is largely dealing with what is the Defense-Based Act. Admittedly, Dave and I have never handled one of these types of cases. Lindsey, I don't know if you guys have in the firm, but it is worth bringing up because there are so many folks who get hurt while overseas, and it needs to be discussed a little bit. Dave, kind of give us the bird's eye view for just a second or two, and then we'll hit some highlights in this one.
Sure. So this is workers' compensation, also known as the Defense-Based Act, but it's not just for people that work in the state of Alabama. All right. For instance, the Defense-Based Act covers civilians who work for a private employer on a defense base, and that defense base can be both in the United States and it can be overseas. A defense base is land owned or occupied by the U.S. for military purposes that is outside the continental United States. So I guess I misspoken just a minute ago when I said it could be in the U.S. or outside of the U.S., but it's military land outside the continental U.S. So it covers civilian contractors who work for the U.S. or doing U.S. government agency work. It's similar to work comp in the sense that that for someone to be covered for an injury or a death, they have to be the accident has to occur or arise out of in the course of their employment, which is a very similar standard that we use here in Alabama for our work comp cases. They also talk about in the Defense-Based Act, it's called the zone of danger. So even if it didn't occur during work hours or during the performance of duties, that they still may be covered. And I imagine that's a scenario when someone is asleep on a defense base and they're injured that way through something, or they're close by an accident. So that's it in a nutshell. And this article talks a little bit about injuries being covered after they return to the U.S. As you know, most civilians, contractors were just left Afghanistan in the last couple of months.
Lindsey, one thing that caught my attention that is not part of Alabama law is the PTSD would be covered, I think, even if you don't have physical injury in this scenario. Is there anything else of substance that really caught your attention dealing with this?
Well, and of course, I didn't look into any other, research into this, but one thing that did catch my eye in that first paragraph, it talks about that federal law requires employers to compensate for injuries that occur during transportation. So to or from, when the transportation is provided by the employer. So I thought that was interesting. Just, obviously the transportation there is much different than probably anything that we deal with. Getting somebody to Afghanistan and back is not the same as, driving an hour to work or whatever it may be. But I thought that was interesting just because of what we see, generally the coming and going rule where employees here, I mean, if you're just, going to and from work and you're hurt, generally you're not going to get any benefits. There are exceptions and, fact specific type things, but I thought that was interesting. And I'm sure it's, just the amount, what that travel entails is very different than your everyday type situation.
I'm also envisioning that these injuries are going to be significant injuries, just given the nature of the type of work and the exposure of where they are in the world and hotspots, so to speak. But let's pivot from that one and let's move on to, again, article or a topic that seems to come up every month, Dave. Marijuana waxes as opioids wane in workers' comp. And before we jump into that, Dave, we talked about this before, about how in Alabama, unfortunately, I guess it's the northwest part of our state, there's certain counties that have the highest significant, per capita prescriptions of opioids, I think, in the country at one point. I don't know if that's...
At one point, it was the world.
Yeah.
Wow.
And I think that's all been largely dealt with, but for a period of many years, I don't know if it was a specific clinic or doctor or doctors, but sadly, the eyes on Alabama for that poor reason. But maybe this is a shift. Maybe this is with medical marijuana becoming more and more acceptable around the country. What do you think about this, Dave?
Well, what we've talked about several times on this show is that there's opioid abuse, and doctors are trying to get away from prescribing opioids. And the question becomes, if they're not prescribing opioids, yet people are still in pain, how are doctors going to treat their pain? And 10 years ago, you would never thought marijuana would have been the answer, as it wasn't legal anywhere in the U.S. And now, 10 years later, it's becoming more and more recognized as a way to treat pain.
Have either of y'all seen any of the research lately? How many states now accept some versions of medical marijuana?
I did see that. I was looking when I was reading through this article. I can't remember the number. Was it like 30 something states that now allow?
You're right. 36 states now allow medical marijuana for a broad range of uses and conditions.
Mm-hmm.
And then just bringing this specific back to Alabama, we all know that Alabama lags behind almost every state being progressive with laws and protections for workers. But given the recent past history of how badly Alabama has responded to this, or had to have to deal with the significant percentages and high numbers of opioid problems. I'm wondering if Alabama will reverse its trend and become a leader at some point dealing with this, because the amount of money that's illegally spent and used in our state it's remarkable given the per capita compared to other parts of the country. So I don't know if any legislation that Dave's being proposed that would change any of this that you've seen.
Not that I'm aware of. But I do want to address something we talked about early on. We talked about telecommuting, people working from home and how that can save employers money. And at the end of this article, there was a claimant's attorney from Pennsylvania was interviewed as part of this article, and she talks about the savings to work comp carriers and to employers. Mm-hmm. And that right there is the reason I think we'll see more and more use of alternatives to opioids like marijuana, because at the end of the day, these insurance companies are about making money for their owners and their shareholders. And if they can find a way to make money, even if it means reimbursing marijuana or paying for marijuana directly, then that's the route they're going to go, because it's probably cheaper than opioids. And if doctors aren't writing prescriptions for opioids, they'll go that route because it saves them money.
One question, and y'all may know this, because I kind of found conflicting reports on the new bill that was adopted for medical marijuana in Alabama. One thing I saw in several places that chronic pain was not a condition that would allow for medical marijuana, which, obviously is concerning. It looked like they kind of restricted it to more of, the side effects of chemo. And I can't remember all the other different ones, but that was one thing that kind of caught my eyes, that they're excluding chronic pain from one of the conditions. Hopefully that will change. Who knows?
The trend during my practice, and probably you guys have seen it just like I have, one of the biggest arguments in an Alabama workers' comp case, one of the biggest hurdles, is not just causation, but the sheer costs. Mm-hmm. That's in the back of the mind of the insurance companies. We're going to deny this and push it off and push it off and push it off in hopes that either a personal insurance company will take it over, or the client, the injured worker, not the client, but the injured worker doesn't want to fight the fight because it's so expensive and so takes so much time. My point in bringing this up is I'm wondering if the medical use of marijuana then will ultimately lower a lot of those prescription costs that may allow our clients eventually to get some of the care that they truly need. Mm-hmm. Instead of having to, because we're going to get the utilization review in a minute, and nobody wants to talk about it, but it's just the evil we have to deal with in our cases. But anyway, let's put a cork in that one. We got one more article before we get into our Alabama laws. This one's coming out of New Jersey. New Jersey work comp law requires employers to give hiring preference, can't talk today, to previously injured employees. First of all, I'll ask, Lindsey, is there such a monster in Alabama?
No.
David, have you ever
really
heard
surprising.
In any?
This could be this article came off the Onion. If you handle the kind of work we do, I read, I was like, what is going on here?
Yeah.
Well, it's got an interesting twist to it, mm-hmm. that it applies to employers of at least 50 employees, and it protects, I'm just reading out of the first paragraph, protects only employees who were injured at work and have reached MMI under the work comp laws of New Jersey. And there's a few other disclaimers, but could you imagine, let's try to apply that to Alabama. How in the world would that ever work here? Man, you'd have so many fights.
I read this 3 times and I still was like, wait, really? I'm shocked.
Well, it was signed, let's see, I guess it was in September, effective immediately. Dave, we need to get a New Jersey practitioner on here in the upcoming months to talk about how this is played out.
Yeah.
Maybe in the spring we find somebody to see how this has impacted their practices, because let's bring this home. We all have injured workers at Walmart, and they almost always just get relieved of their jobs immediately. Could you, I mean, just the sheer volume.
Yeah.
It just doesn't seem very practical, but
well, and another thought I had was, kind of flipping it. Would it affect, let's say you've got a guy that's injured and, I can't even think, whatever job he was doing. If he can't go back to the job that he was doing, then, we're going to argue that he's permanently, totally disabled. Is it going to affect, and I don't know how their laws are, but will it affect their ability, if they say, well, we're required to give him preference on this other position. If it's a lesser paying position, is it going to lessen the argument that we would have that he's totally disabled, because it's like, well, we offered him a job, we had to, because we're required by this new law. So I don't know that, it could be good. It could be bad.
When you say it like that, Lindsey, I read this article as a good thing for employees, right?
Mm-hmm.
When you couch it like that, I could almost see it where employers would use it as a defense to those cases where we say someone is permanently totally disabled or catastrophically disabled. Mm-hmm. So it's interesting that.
Yeah. I'm curious how, a year in, how is it going to affect their practice? That's interesting.
And so many of our settlements, the employer requires a voluntary resignation and an agreement not to reapply for work.
I hate those.
Yeah.
God, I hate those.
Yeah. Very interesting.
Yeah.
It is interesting. We could easily have this conversation today turn south in a hurry, and we could grouse about the parts of our practices we don't like, but I'm going to have to stop you guys for now, because we're on a public forum and we don't want to give the wrong impression. But those are our articles for this month. There was no shortage of articles. We could have talked about 50 articles this month, but I just wanted to give a little flavor. And what we're going to do now, as we do on our monthly work comp today, is we're going to pivot just a little bit. We got a few more minutes left in our time. We're going to talk about Alabama laws, the practice that we do, the three of us, and some of the laws that impact our clients, our injured workers' clients. Typically, when we have a guest who's from out of state, we'll compare how crappy Alabama laws are to how great New York or whatever other progressive states' laws are. But we're going to kind of get muddy here. And the first thing I want to talk about, now our buddy William Powell had a great case many years ago that helped injured workers deal with pharmacy issues. And so I want to talk not necessarily all about his case, but I want to talk about when an injured worker is prescribed medicines by the authorized treating physician. Lindsey, what do you usually tell your clients about, well, how does that work? How do you get your prescriptions? And this is how things go. And why can't I just pay for it and get reimbursed, or have my primary care doctor prescribe it because I get it quicker? Why don't those things work? And what's the smoothest way for your clients to deal with prescriptions?
I wish that it was consistently smooth in every case, but it never is.
It never is.
And I've got some clients who, the depending on who the insurance company is, they give them this little card and they present it at the pharmacy. Not 5 times out of 10, it works fine. They get the, prescriptions. The other 5 times they say, well, they're not approved, or your card is expired, or, so it really is all over the board. And I do have clients who will call and these are, I can think of several clients that are in pain management. They get the same prescriptions every single month, and they have for years. And I still get calls, sometimes monthly, of, hey, I'm at the pharmacy, they're denying them. And it's just the same. And so it seems like it's never smooth. And so there are times where my clients will just say, well, I'm going to pay for them out of pocket. And then we have to go, get them to reimburse it. But then I have plenty of clients who they don't have the money to spend, $75 or, some of those medications are hundreds of dollars. And so they just don't have a way to pay it. And, so, I mean, I can tell you, worst case scenario, I have had clients who have been on, certain medications that are used for like chronic pain that you can't stop cold turkey. You have to take them. Yeah. And, I mean, truly worst case scenario was one of my clients was sent to the hospital and put into the mental facility because had such a bad reaction from coming off cold turkey. So, that is most definitely the worst side of things. But, it just seems like I will have half of them over here. They're paying them, they're approving them every month. And then you have the other half that it is a fight every single time.
It is. And then Dave, I want you to pick up where Lindsey just left off. What happens when an insurance company makes that arbitrary decision without notice and just sends our client a letter saying utilization review or whatever they're going to justify it? We think you've been on this medicine too long. How do you deal with that?
There's a lot of different ways to deal with it, but let's start with this. As long as the authorized treating physician says that the medication or the treatment or the diagnostic exam is reasonable, medically necessary, and related to the on-the-job accident, work comp has to pay for it. Now, work comp can go get a doctor in another state to review those medical records and say, oh, we've looked at this and we don't think this is related or we don't think this is necessary, even though that doctor has only reviewed a select amount of medical records and has never actually seen our client in person.
They never do.
Yeah, that's called utilization review, and they're allowed to do that under our laws and our regulations. However, the authorized treating physician, his opinion overrides that utilization review doctor. And so we can go directly to a circuit judge and on whether a motion or have a what we call a mini trial or a bifurcated hearing and have the judge determine that it was in fact reasonable, medically necessary, and related, and have the judge order that treatment, that test, whatever it is, be approved and ordered by work comp.
And Lindsey, have you ever had a circuit judge rule in the favor of utilization review where the insurance company gets to stop the medical care because they sent it to a podiatrist in New Mexico for an orthopedic back injury case?
Or a dentist. We've seen a dentist.
Yeah. Have you ever had a circuit judge rule against you when you're trying to continue that medical care that's necessary?
No. I mean, in my experience, circuit judges hate those for the most part.
Yeah.
When you get into it and get off into the weeds about, well, they sent these, a tiny portion of the records to this doctor out in Arizona or wherever. No, I have yet to have, when we've had to take it to a circuit court, I haven't had a judge yet say, well, I'm going to agree with the doctor that's never seen your client.
Well, that's staying in the utilization review realm. I want to briefly touch on this Department of Labor Ombudsman's job. One of their functions is medical mediations, if you will. And it's a rarely used function, if you will, but it's certainly there. But I can see scenarios, I don't know if I've had one or if it's been a long, long time, where utilization review has then gone to an ombudsman for determination. Have either of you guys had that experience or heard of? Because I know it's available, I just don't know if it's ever used.
One time 10 plus years ago, and it actually turned out to be more of a mediation, just a routine mediation that we do weekly.
Yeah, no, I've never had, I haven't used that.
Yeah, it's, and the reason why I bring it up is when there are pro se individuals who are injured on the job, when they don't have an attorney, very few, if any, have been given enough knowledge to know that that's available and out there. I think it's a wonderful program because you have experienced attorneys or experienced adjusters or people in the insurance fields who can kind of navigate those waters when they don't have an attorney. But let's, again, we're only hitting highlights of certain things about the practice of law in Alabama. We've got two more quick ones. Dave, I'm going to give you 90 seconds to talk about the 220 cap, and then we're going to move on to something else. So briefly talk about it and why Alabama is so far behind.
In 1985, the Alabama legislature put into place something called the $220 cap, which is the maximum paid on permanent partial disability benefits. It went into effect or enacted in 1987. It has not changed since 1987. Therefore, certain body parts are worth certain amounts of money. For instance, 100% loss of your eye is $27,280. Your entire arm is.
Say that. Alabama, it's worth how much?
Your 100% eye is worth $27,280.
And the states contiguous to Alabama, what's it worth?
A lot more. Your arm is worth $48,000. I think your legs worth $44,000. Those numbers, like I said, have been in place for 35 years, and they have not increased since then. It is unfortunate, and I will get off my soapbox and turn it over to Lindsey, who has things to say.
Lindsey, hold on. I'm not going to ask you for your age. I would never do that. But in 1985, David was in 5th grade.
Okay.
David is considerably older now, and the cost of living in 1985 is just a little bit different than it is in 2021.
Just a little bit.
Just a little bit.
Yeah. That in 1987, that was above the poverty level. A family of 4 could survive off $220. Today, it is below the poverty level.
Yep.
I
think it's 43% of the poverty level. 43% of the poverty level.
And if it adjusted over time, it would be about $570, $590, something along those lines.
And would that have put us in competitive, I hate to use this term, but would we even be in the range of other states had we been increasing over time?
Yeah, we wouldn't be last.
Lindsey, how do you tell your clients when you've got to deal with the 220 cap and explain to them, I know you're injured. I know that all of life's stresses have ramped up. We're going to get you through this, but you've got to understand that our laws are so antiquated. So you almost have to set the bar so low when you start.
Yeah.
You set it so high, your client's going to just be even worse. How do you, from a practitioner standpoint, how do you explain to the client, here's what we're looking at, and here's what you got to deal with?
Well, I mean, I try to have those conversations early and often. And that's what I always tell them is that this is not good news. And I understand that, but I would much rather if we have a choice of reaching a settlement or going to trial, the worst thing in the world is to have a client turn around and say, well, why didn't you tell me this? Because then I don't feel like I've done my job. I just tell them in, a very professional way that our laws are crap, is the way that I put it. And so, but I actually have a sheet that sometimes, especially with like a scheduled member injury, that I will go through and I will walk them through, quickly. Nobody wants to sit in a lawyer's office and go over math, but I show them like, here's, if we go to trial, here's what could happen. I try to give them worst case scenario, best case scenario, and something has to be done, but we work with what we got.
That is so true. And I've got 2 more minutes before we get out of here with another monthly episode of Work Comp Today. And this is for both of you guys. It's not on our script. It's not in our articles, and I'll start with you, Lindsey. When you've got someone new coming to you, new caller, or they stop in and they've got a potential case, they're looking for answers. Mm-hmm. And the biggest fear is what we don't know, of course. How do you convey to your clients, and this is a little bit of what we've just kind of talked about, how do you convey to your clients that you're going to guide them through this process, good, bad, or indifferent, It is what it is, but we got to get through it.
Yeah.
What's the best thing that you and your staff do that gives them, hey, my lawyer's working for me. She knows what she's talking about. She's not brand new and making this stuff up. What do you say to your folks, your clients?
Well, I mean, a lot of it is on the front end. I do try, like I said a minute ago, I try to walk them through and say, here's what we're looking at. Like, here's the parameters of our law, what we can work within. And sometimes, and I'm sure y'all may feel the same way, you're talking to so many people, and I have to stop and remind myself, this is probably the worst time in their life, right? This is the worst thing going on, and they're calling us for help. And so we try, and we don't always do it perfectly. I wish I could get everybody called back, and, but there's always questions. And sometimes it just helps to bring them into your office, which, that changed a lot during COVID. It was a lot of phone calls and emails, but sometimes just bringing them in, let's sit down together, let's look at everything. And that, at least I found, helps tremendously. Because I think if they see you face to face, and you kind of walk it through with them, that does help put them at ease.
It's Dave, Lindsey's so right about that all of life's stresses ramp up everything when a person gets hurt on the job, because it impacts their health, their employment, their compensation, their family dynamics, their way of life. But what do you do? What do you say to injured workers who are calling you looking for answers? Whether you take them on as a client or not, how do you convey to them some comfort?
Well, yeah, one of the things, we've been doing this long enough, all three of us now, to where I can say to the person who I'm talking to, hey, I've been doing this for 18 years. I've been representing injured workers for 18 years. It's pretty much all I do now. And I've represented thousands of workers, many like you, worked at that same plant, worked at that same town, worked for that same employer. And so I've given advice over the years, and I've been through trials, right? I've dealt with these cases before. So I'm basing, listen to me because I have experience, and I've guided thousands of injured workers through this process. So that's why you can trust what I'm telling you. And I'm going to give you the best information I can based on the laws, even if we don't like the laws, even if we're trying to make the best out of a bad situation. I've got experience. And Lindsey, you can say the same thing, to these, and Bernard, you've been doing it long enough. We can say, I've represented thousands of injured workers across the state. So listen to what I'm saying.
Yeah.
Now I'm going to make you both cringe as we conclude. The caller on the other line, I've been doing some research, and I want you to know my case is worth X.
Yes. So
anyway, I don't mean to make fun, but we all deal with it in our own way. We have to.
Or Bernard, my brother got injured, and he got $280,000.
Yeah.
All right, I got to call a timeout. No more. We're done. Guys, I want to thank you both for spending some time. Dave and I, Lindsey, have thoroughly enjoyed, obviously, our friendship over many years with you, but we really appreciate you making some time today for our monthly work comp today, and just going over articles and things that hopefully some folks out there get a little bit of education, learn a little bit more about your firm and you, and we tolerate Dave most months, but thank you for spending some time with us.
Yeah, thanks for having me.
Absolutely. Dave, any parting final words from you?
Roll Tide, go Braves.
There you go. There you go. Guys, this is our monthly work comp today. This is October 28th, 2021. We'll be back at maybe the third week in November because of Thanksgiving. And we really appreciate anybody who watches and interacts with us. But we'll just keep coming back each month. So you guys have a safe Halloween coming up and holiday.